Hello, everyone. Welcome to the Charity Leaders Forum. These are our lunchtime learning sessions that we're running every quarter. I know that some of you have been before, and we've got some new attendees, so you're very welcome. I'm Bhayani, Managing Director at Bhayani HR and Employment Law, and we put on these sessions, try and find topics that we think will be of interest to the sector, and I'm really delighted to see, how popular they're becoming. So hopefully they are of value to you. So in the past, we've done a number of topics. We have done things on diversifying your trustee board and generally equality and diversity training. We did a session with Steve Chu last time on charity mergers, and we did an AI ChatGPT training specifically for the sector and how best to use it for funding applications and things like that. And I think this one has proved to be quite interesting. So we were thinking that, in this current climate, there are lots of charities that are struggling financially. So we thought it'd be useful to put something together to help you think through the options available to you. And those options really range from some softer approaches, conversations and consultations with employees to change certain terms through to redundancy from our point of view, and insolvency at worst, which you'll hear more about from our contributors from Leonard Curtis. So when at the end of the session, you'll receive a feedback form, and we would very much like you to complete this to get a copy of the slides. But what I'm really interested in is what sort of topics you want to hear from us in the future with, so that we can put that together. And if you want to contribute to something, or a good contributor, then please do get in touch on the feedback forms, or just send us an email. Okay, so I'm going to pass you over first of all to my colleague Hannah Haywood, who's an employment lawyer within our team, and she's going to look at some of the employment and HR implications where your charity is facing financial issues. And then after that, we'll hear from Deborah Lockwood and Danielle Shaw from Leonard Curtis, which will be really interesting to see what kind of measures can be put in place aside from the employee issues. Okay, so enjoy the session.
Thank you, Jay. Sorry, we've just had a couple of really swift technical issues. I've just popped in. So just as Jay covered, this is obviously a bit of a support network that we've began to develop with charity leaders throughout South Yorkshire, and hopefully you find these sessions really beneficial. Just to say, if you have any questions throughout this webinar, then please put them in the chat box, and we'll have someone monitoring that, and we can answer them at the end of the session, just because it can be a little bit difficult stop-starting, and we might hopefully very well cover some answers to your questions anyway throughout the session. So yeah, either keep a note of them yourself to ask at the end, or just pop them in the chat box and we will go through them. Lovely. So just a quick one on what we're covering today. As Jay explained, we are going to go through a couple of bits with me, and then we're going to pass through to our friends at Leonard Curtis, who will go through hopefully some really interesting stuff that will prove to have some benefits to you all, I'm sure. But generally speaking, I will be covering the initial stages, the very early warning signs, what you can do to avoid needing to make maybe some more serious decisions later down the line, some general cost saving exercises. And then, as I say, we're going to move through that process with Leonard Curtis, and they can explain further how it is that we can help. So I think, unfortunately, there are many industries and many sectors at the moment that are experiencing some financial challenges. And we just want you to be aware that there are many options that you can consider should you start seeing some warning signs, and act fast enough, really. There isn't too much of an early stage to get in touch if you do need some help and you do think you're going to need to start thinking about some of these things listed here on this slide, such as potential redundancies, temporary layoffs. Some of them obviously are much more severe than others, but hopefully we're going to whiz through some of them and give you a bit more information, and they won't seem quite as daunting by the end of today. So the big one, and I think the one that a lot of people immediately go towards, are redundancies. So obviously, if we are looking at making cost savings, staff can be generally quite expensive. And if you have got staff either in the wrong areas, or you have departments that aren't quite structured as you would like them to be, then redundancies can be a really good option. Now, these aren't the only option, and sometimes they're actually not that much of a cost saving exercise because they can be quite expensive to do. And they can be even more expensive if you get them wrong. So the key thing here that I really want to get through to you is the process of a redundancy and how you make sure that that is right. So a redundancy only occurs whereby the role itself is considered redundant. So either the dismissal is wholly or mainly attributable to the employer when they cease or intend to cease to carry on the business. So, you know, the whole business, unfortunately, is having to close, and therefore all of those roles are redundant. Or there's a certain department, a certain workplace, either a location or an area where you think the roles within that department either need to be reduced, and therefore a certain number of roles are redundant, or a department may indeed close in an entire area. So having a reduced requirement for employees to carry out work of a particular kind is likely to result in a redundancy situation. The process for a redundancy can often seem quite long. I promise you it doesn't have to be always. Sometimes it does have to be longer than others. However, it's the process that's going to be scrutinised. If you are in a position whereby you will not be closing the business, and actually the business can continue to run quite profitably, however, you do need to make some redundancies, this is probably the most dangerous area, because there will be a business continuing to trade, and therefore one that is eligible to be pursued in the employment tribunal. And it's the process that tribunal judges will review rather than whether it was necessary to make the redundancy in the first place. So that process must be considered fair, and it must be a full process undertaken. The main thing that I would recommend is to plan for your redundancies. If you get to the point where you think, right, we need to start considering some redundancies, then make a plan. What's that going to look like? Is this a full restructure? How is that department going to be shaped once these redundancies are made? Then how are we going to make these redundancies? What's the selection criteria going to be? If we're reducing from 5 to 3, for example, and we need to get rid of 2 roles, they may all be in a similar pool. How are we going to assess who stays and who unfortunately does not? You know, get that all clearly documented down. That's going to be your biggest defense if anybody comes and starts questioning whether that was a process that was manipulated in any way, or whether that was a fair and transparent process. You must also inform all employees who are at risk of redundancy. So again, quite early on, there's been quite a few case studies actually that have come through where tribunals have been quite vocal about employers not being as transparent as early as they should have been in relation to potential redundancies. We don't want to be getting to the point where actually they're going to be dismissed by the end of the month, and we're on the 15th of that month, and we're only just telling them that this is something we've been talking about for maybe a couple of weeks or months before that. I appreciate that's not always going to be possible, and things do move rather rapidly. However, as soon as you believe that this is going to happen and we are going to be making some redundancies, we need to be informing all employees who are potentially at risk. We must then undertake a consultation process. And this is the bit that actually I think is the easiest thing for employers to do to ensure that they are protecting themselves from any future claims against anybody that they are going to be making redundant. So that is to show that you have properly consulted with these employees. So consultation can sound like a big scary word, but it's essentially just a few meetings to discuss why you're making redundancies. Are there any other alternatives? You know, do you have a part-time role, but actually this person's full-time? Have you spoken to them? Would they be willing to drop their hours? Could have been something they've been thinking about anyway. It could be a different role. It's all about communication and ensuring that any questions those employees have, they're given the opportunity to ask. And you may not necessarily have the answers right away, but that's fine. You are more than entitled to go away and say, I'm going to find that out for you, because that's a very good point. We'll look into it. We'll get back to you. And it might be that some shuffling actually reduces the need to make redundancies, maybe not entirely, but it's always a very good way to investigate, how that redundancy is going to look by the end of that consultation process. And just a final point, remember the post must be redundant, not the person. So we don't look generally, 5 in that department and you're the one that's going to be made redundant. No, one role is, and who that is to be will yet to be decided at that early point of consultation. That's going to depend upon the selection criteria, the consultation process as a whole. And, you might want to ask for voluntary redundancy. Some people might be interested in that. Don't be afraid of asking that, because you don't have to accept every hand up for voluntary redundancy. So obviously you can just have those conversations internally to see if it would be suitable. So the process, quite generally speaking, as I say, you identify which employees are affected and determine the selection pool. We plan and we document that plan. The selection itself, so the selection criteria, are we looking at experience? Are we looking at length of service? Are we looking at qualifications? Are we looking at disciplinaries? Collective. Now, I'm not going to go into detail in relation to collective consultations for redundancy, but you do need to ascertain if that is necessary or not. If you're unsure, I would recommend getting in touch with us directly, because that is something that we can help guide you on. And there are a few more boxes to tick should it be a collective consultation. The consultation itself, so individual consultation meetings, how are they held, who needs to be there, what kind of notice needs to be given for those meetings, all those things need to be considered. And compensation. I would highly recommend that you do some sums at the start of the process rather than at the end of it, because as I say, it's not always the easiest cost saving measure. And it's certainly something that you need to start calculating at the point they're going to be made redundant. So you might do those sums at the beginning of the year, and things might change if you're passing over April, or if you're passing over somebody's birthday, or passing over somebody's anniversary of when they started and they've got another year's service. Make sure you've done those calculations accurately. And again, if you're unsure about what any of that means, then do just get in touch with us directly and we can certainly offer you some guidance. As I say, a plan is the safest way. A paper trail, it can be the most important tool in your defence. You're going to need to be able to point to that should anybody question their redundancy and say, look, this was all in the plan. We made a decision that this was unfortunately going to have to be the case, and in line with the selection criteria that we'd already decided was going to be, how we assess people, this is the outcome. And, it's unfortunate that these things happen. All of our clients, whenever they come to us and are asked, come to us and say, unfortunately, it looks like we're going to have to make some redundancies, they are always asked to complete a full redundancy pack prior to any processes taking place internally. So that's a bit of a sounding board for them and for us to say, right, have you thought about this? Have you thought about this? Have you considered this option? But also it's a really good piece of evidence to say, look, we haven't targeted that one individual. We haven't manipulated the process. This was all in the plan. The employees were informed and then they were consulted, and that amounts to a fair dismissal, which again is going to be really, really important should anybody question the process. So again, just the general process goes from notification, so you inform them, you consult with them, we go through the selection process, which can look different dependent upon the department that you're looking at, dependent upon the pool of at-risk employees. The notice period can be very important. Are they going to work their notice period? Are they going to be paid in lieu of their notice period? How is that going to work, and how is that going to fit the needs of your business and your organisation? And the final resolution, so after the notice period, are they formally terminated? What's the payment plan in terms of those final payments? Are you aware of the tax implications of those final payments? Again, all those things need to be taken into consideration, and the employee does need to be informed of how that's going to work, because that's probably going to be their first question. There has been a recent change to redundancy protection. So a woman who is on maternity leave is protected against redundancy. That has been the case for quite some time now, if there is a suitable alternative vacancy within the organisation. So this also applies similarly to those on adoption leave and shared parental leave. However, it previously ended when the new parent returned to work. So during that period of maternity, if there was a suitable alternative role, so that's not every role, that is just those limited to what would be considered suitable. And there are a number of factors that would be taken into consideration when you're looking at suitability. Then the person on maternity leave or adoption leave would have the absolute right to be slotted into that role. Okay. Now, as I say on the slide, that did end at the point they returned to work. So they could have been off for a year, come back to work the following week. That protection's gone now. However, the law did change in April this year, and it extended that protection. So what that now means is that from the birth of the child, they are protected for up to 18 months. So dependent upon how long they take off as leave, for example, if they were off for a full year, they would still receive 6 months enhanced protection from their return. So that's obviously going to vary, the protection upon their return. It's going to vary dependent upon how long they've had off from the birth of that child, but it extends that redundancy protection. It'll work in the same way as it did before, in that if there is a suitable alternative vacancy at the point they're put at risk of redundancy, then they will have the right to be slotted into that role above somebody else. Okay. Now, this does not mean that you can't make people returning from adoption leave, maternity leave redundant. This is only in the circumstances where there are no suitable alternative vacancies. And as I say, the suitability of a role depends on a number of different factors. There's no set list that you look at and go, right, okay, we've ticked 5 out of 7 of those boxes, and therefore it must be suitable. This is going to depend, as I say, upon the circumstances of the organisation, the circumstances of the individual. But provided that the redundancy is genuine and a fair process is followed, an employee with this protection can still be made redundant. So it's not, as all-encompassing as it might initially sound. So moving on from redundancies, I know that was quite a detailed look into redundancies. There are obviously other alternative money saving methods essentially that you can consider. A lot of these were considered in a lot more detail during the COVID period and shortly after, when there's a lot of uncertainty, but we thought it'd be really helpful to just recap some of those things that you can do as an employer to potentially either limit or avoid redundancies, or limit and avoid having to get to the point of, potential insolvency later down the line. So temporary layoffs. So that means that you can provide employees with no work and no pay for a set period whilst you retain them as employees. And short-time working, meaning that if you've got less work, the employee can do that less work and less pay for, again, a set period of time whilst retaining them as employees. Now, there are very certain and limited circumstances whereby these things are possible and legal, and therefore we wouldn't just recommend, going in next week and being like, right, okay, you're all temporarily laid off until I decide what's happening. That will probably land you in some hot water. But it is a rather temporary solution if you are considering, alternatives to making redundancies, and if you're a short-term measure, should you be waiting on, a big contract to land or a big tender to come through. Employees may still be entitled to a statutory guaranteed payment on up to 5 workless days. So if you are looking at a temporary layoff, and for example, it may be that you're reducing from a 5-day week to a 4-day week, they may still be entitled to a guaranteed payment. Now those figures are specified on the slides. And again, if you're unsure at any point, please do get in touch with us, because it's quite specific. And those who work part-time, their entitlement is also worked out proportionally in line with that. But it's not, it's not going to be a case of we're laying them off and that you've no rights to them anymore. They're still going to accrue things like holiday pay and be entitled to a certain amount of payment. It's just likely to be much less than what you were paying previously. As I say, important things to remember: annual leave will still accrue at the full rate during any period of layoff or short time working. So you're not going to completely remove all obligations there, and you may still need to pay your employer contributions to the pension during any period of temporary layoff or short time working, but I would recommend you check with your pension provider in relation to that. As I say, it's not an unlimited amount of time that you can say to somebody, right, I've got no work for you, I'll ring you when I have. It's quite a limited amount of time to 4 weeks in a row, or 6 weeks is any 13-week period. So the first thing that you'd need to do is check whether there is any right in the contract for you to do this, and if there is a clause that allows you to lay somebody off temporarily. But you do have to make sure that this isn't for an extended period of time. So should you temporarily lay somebody off for more than 4 weeks in a row, they could, and again, this is only in very certain circumstances, they could be entitled, therefore, to ask for their redundancy, and they'd be automatically considered redundant at that point if it's any more than 4 weeks in a row. So it's quite a niche area, and as I say, I wouldn't recommend just laying anybody off temporarily without some specific advice. However, should you have it in your contracts, and I think if some of you are our clients, you very well might do, that you do have clauses that permit temporary layoffs or short-time working, then you can look to implement them with immediate effect. Your contract may say that you have to give notice, so you give somebody potentially a week's notice that as of next week, fortunately, we're laying you off temporarily, only for a week, only for 2 weeks, etc., and that would be fine. Now, I would recommend that you have a face-to-face meeting explaining the situation, because just coming in and telling somebody you don't need to come in next week can be quite terrifying. But if you sit down and explain the situation and have a discussion and a consultation, generally employees can go away feeling a lot more assured that this is only a temporary measure to look at a more sustainable long-term solution. I would recommend that you confirm it in writing in a letter that you're enforcing a period of layoff or short time working, and refer to the clause in the contract that allows for that. Explain why the decision has been made in the letter, and inform them how long the measures are likely to be for and how the guarantee payment works. If we are laying somebody off, this is how much money they're going to receive, this is how much we're going to pay them, and how many hours you are going to need them to work if you're looking at short time working instead. And as I say, if at the end of a 4-week period of temporary layoff, you don't think you'll be able to provide work within the forthcoming weeks after that, then you will need to place them at risk of redundancy and begin a consultation period with a view to ending their employment. Now, if the contract does not contain any layoff or short-time working clauses, you can only impose this with the agreement of your staff. So consent is key. If you believe that the current downturn in business is likely to result in redundancies, that might be a conversation that you have. Would you be agreeable to consent to a temporary period of layoff? Would you be agreeable to not working for 2 weeks? With the alternative being, if you didn't, we'd be looking at making redundancies, and therefore there may be no job at the end of those 2 weeks in any event. Again, a short-term solution potentially to assist the business more long term. And I think if you have those conversations with your staff and they're kept in the loop and they feel involved in that decision, then you're going to have a much better chance of obtaining their consent and varying their terms and conditions of employment. Okay. In line with that, there are other contractual terms that you can potentially ask your staff to agree to. Now, those include their hours. Can we temporarily reduce your hours? Can we temporarily reduce your pay or benefits, if they're of any cost to the business? And as I say, the starting point here is consent. You need the agreement of your staff in order for this to be lawful. A contract is a legally binding agreement between two parties, employee and employer, and neither one of them can vary those terms without the consent of the other. So just as much as they can't come in and go, you know what, I'm going to drop my days, I'm going to go from 5 to 3 and, see you later. They can't do that just as much as you can't do that to them without their consent. Now, again, they may be much more inclined to agree to the change in their terms if the alternative is worse. Unfortunately, if we are looking at potentially closing the business, if we don't deal with these issues in the short-term basis now, they may be much more inclined to agree to that change. So again, it's all about communication, really. And temporary variations to the contract must be recorded in writing. So if it's a temporary change or if it's a permanent change, permanently somebody's dropping their hours and that's an agreement with both parties, then we'd always recommend that that is recorded in writing. It just has to be a letter signed by both parties to say, yeah, this is what's changing, everything else is staying the same, but we both agree to that, and that's going to be kept on record, just so that there's no confusion there moving forward. So as I say, there are a number of different terms of contracts that you may wish to consider if some are much more costly to the business. You don't necessarily have to jump straight to, right, we need to make redundancies and everybody's out. I would recommend that you take it step by step and try some of these alternative methods first in that cost saving measures. And I just wanted to touch on 0 hours workers. So, if people have got employees on 0 hours contracts, and it is a genuine 0 hours relationship and there's no pattern of work established, then, if there is no work that week, that is the point of a 0 hours contract, that you have no obligation to give work if there is none, just as much as the employee has no obligation to accept that work. However, we've seen it much, much more, I'd say, in the past few years, that there has been a pattern of employers having employees on 0 hours contracts when that's not the reality of the situation. And actually, the number of hours they work every week is the same. They're consistently working 35 hours a week, and they've therefore established an implied term of custom and practice where they'd expect to receive those hours every week. And therefore, I would not recommend that you rely on the 0 hours contract to remove those hours that you've been providing just because that's what's written on paper. Because if that did get tested in front of a tribunal judge, we've seen it quite a few times now, that they will look to the reality of the situation rather than what's written in that agreement. So I think, number one, make sure that all your written agreements between your staff reflect what is genuinely the case. But also, number two, if you have got people that are not genuinely on 0 hours contracts, then you may be held to more obligations to provide the hours, and you may have to look at what we've just discussed previously in relation to the contractual terms for short-time working, or to get their consent to vary their terms rather than just relying on what is listed in their contract as their hours. Okay, I appreciate that was a whistle-stop tour, but I think we are now passing it through to our friends at Leonard Curtis. Now, I think Deborah should be able to speak.
Yes, I think we can. Thank you.
Fabulous. Lovely. I'll pass you through. I'll go on mute.
Thank you. Hello, I'm Deborah Lockwood, and I'm one of the directors at Leonard Curtis, with my colleague Danielle Shaw, one of the associate directors and licensed insolvency practitioners. At Leonard Curtis, we deal with all types of restructuring, turnaround, insolvency work, and solvent-led wind downs for companies as well. And what we want to do, can we move the slides? Oh yeah, sorry. There we go. Sorry, there we go. For the purpose of this presentation, what we're wanting to do is to provide an understanding of the term. A lot of people use the word insolvency, and it really can be multifaceted, and it often isn't as doom and gloom or as terminal as people often think. It can involve restructuring, turnaround. It can involve insolvency options, which we will also cover in this presentation. But as you've been told before, a lot of the ability for organisations to have more options is to get early advice. We also want to be able to provide information that will assist you, your fellow directors and trustees, on the early warning signs that could ultimately lead to an insolvency, some do's and don'ts when a charity may be facing them being potentially insolvent, and also to identify non-insolvency options that may be available. I also wanted just to mention that what we're going to cover in this presentation, which again is going to be a whistle-stop tour of things, relates to charities that are limited companies, CICs, entities which are limited by guarantee without share capital. if the organisation is only registered with the Charity Commission, different processes will apply, and you can contact us and we'll go through those on an individual basis. So I'll just hand over to my colleague Danielle, who will take us through the next part of this presentation.
Hi everyone. So as Deborah mentioned, I'm one of the licensed insolvency practitioners here at Leonard Curtis. And what I wanted to talk about is what is insolvency. You know, under the Insolvency Act, you might think it's, you know, there's various ways of measuring it, but there are two proper tests that we class as determining an insolvency. So the first one is the balance sheet test. You know, you are looking at where the liabilities are greater than the assets of the charity. But the bit which I suppose really sticks out for charities in particular are the future and prospective liabilities. The next one is the cash flow test, and that is when a company or a charity is unable to pay its debt as and when they fall due. You know, or simply put, you know, creditors are chasing the business and there aren't insufficient funds in the bank account to pay them at that time. It might be that the company has got capital assets, but if it hasn't got the sufficient fluid assets, it's considered insolvent. And it can be one of those, both of them, etc., just to determine insolvency for a business. So one of the points we wanted to talk about is, and when we refer to directors here, it also covers trustees as well of a charity. And I think a lot of the cases where we've come across with the charities are the trustees are registered at Companies House as directors of the company. So when a company is solvent and has no financial concerns, broadly speaking, the directors have got limited duties to the creditors. But when it is insolvent or verging on insolvency, or it might be that the company, because of contingent liabilities, knows it's going to become insolvent at some point in the future, the duties shift from being to the potentially the beneficiaries or the trustees towards the company's creditors as a whole. The critical point for a business or a charity is when the directors ought to know or knew it was insolvent, and what action did they take. And I think this comes back to Hannah's point on documentation. You know, like we were saying about the redundancy process and keeping documentation. One of the things we always say is that trustees should make, whenever they make a decision or they're reviewing the position of the charity, is document their decision and why are they continuing to trade, why are they applying for new funding, etc. And it's always really helpful when looking at the situation further down the line. So at some point, there is going to be this tipping point where the directors or the trustees realise, or should have realised, that the company was insolvent. At this point, it can be a breach of the duties and can result in personal liability of the trustees. If it is, like Deborah said, a company or a charity, sorry, that's registered at Companies House, limited by guarantee or a CIC, it could be that the trustees as directors could face disqualification. So following on from those points, I've just got sort of some case studies to mention as well, is what we have seen in the past is that whilst directors and trustees may believe that the charity is solvent, there may be the contingent liabilities that need to be considered. And the main ones that we have seen in the past are redundancies, pension deficits, and lease agreements. So for instance, redundancies, I've dealt with a charity in the last few years where, you know, they had cash in the bank, but unfortunately the funding changed. They were funded by local authorities and the contracts were taken away at very short notice. This meant that the charity had to cease, and they had some staff members that had been quite long-standing, you know, 20, 30 years. And so actually when they took into account the redundancy costs for these staff, it made the charity insolvent. And so the trustees and directors made the decision to wind up the charity. one of the things is the future funding needs need to be taken into account. And like I said before, informed decisions need to be made. So it might have cash in the bank, but the funding could be restricted. So we have seen another case where the, I suppose the plan for the funding coming in over the next 12 months was more than sufficient to for the charity to continue trading and providing the services, but the funds were heavily restricted. And so whilst they paid for the charity to run a certain course, they weren't able to use the funds for running of the building, staffing costs, etc., which are actually key to the charity running and then being able to pay for the services. So in that case, the trustees made the decision to wind the charity down. Just to reiterate, like I said, all decisions should be documented by the board, whether you have your regular board meetings with the trustees. And one of the things we have seen with charities previously is that as a trustee, you can also be a director when it is registered at Companies House under whichever form. So, and actually we've had it where trustees turn around and say, well, hang on, I'm not a director, but they are registered. And I think it's always worth checking the register at Companies House to see who the directors are, because you do actually have additional duties, not just as a trustee, but duties under company law. Another thing that charities need to look at are the articles when the charity was set up and the obligations that they may have under that. For instance, I've seen one where trustees have to change every 18 months under the articles, and the liabilities for the trustees there. Did you have anything else to add on those points? Before I go on to early warning signs.
That's fine. We can cover things at the end.
One of the things I wanted to touch now is about early warning signs that we see where charities could have potentially taken action earlier. Oh, sorry, Hannah, I think there's just one more click on that one. Perfect, thank you. So one of the things we look at are the early warning signs, and the earlier that advice is sought, the more options that are available to the trustees of the charity. So the main ones are on the screens, but looking at, bounced direct debits, bounced payments, cuts to funding, removal of bank facilities, arrears to HMRC. I know a lot of charities aren't VAT registered, but they may have PAYE and NIC liabilities as well. And I think looking at the, touching on what Hannah said about redundancies is, yes, you might think that a snap decision on redundancies could be the right thing for the charity, but it is then looking at the overall position and it's saying, actually, are the redundancies going to help the overall position, or could it be that a whole restructure needs to be looked at? Oh, the next slide, if possible, please. Thank you. So I want to just touch on the options that would be available for charities, whether it be non-insolvency options, insolvency options, and the processes that includes. So on the non-insolvency options, you have cash or capital injection and funding, applying for new funding, seeing if the trustees could contribute or whether there would be potential investment from a third party. If the company has got, so if the charity's got trade creditors, or people they owe the money to, you could look at informal arrangements with them, giving them more time to pay. And if there's HMRC liabilities, you could always look at a time to pay arrangement. So they are set arrangements with HMRC over a period of time where the, I suppose, past liabilities are ring-fenced, and then going forward, you agree a payment schedule with HMRC and whilst keeping up with the current and future liabilities. But any questions on the time to pays, would be able to assist with those as well. So if we have a look at the formal insolvency or solvency procedures, the ones you might have come across are the creditors' voluntary liquidations and the administrations. They are available to charities as well as standard trading companies. They're the ones you see in the news. So in terms of the creditors' voluntary liquidation, it's a formal wind down procedure. staff are made redundant, and it is a liquidator's duty to realise the assets of the business. When a charity goes through a formal procedure, employees would be able to make a claim to the redundancy payment service. It's part of it, it's a government department, and they would be able to claim for any outstanding redundancy pay, wages, holiday pay, notice pay, and any outstanding pension contributions. Yeah, it is subject to statutory limits, but any questions on those, we can go through them. And the other one that we see most suitable for charities are the members' voluntary liquidations. So these are a solvent process, and it's where the funds remaining in the charity could then be redistributed to, depending on the articles. So it could be a case where the charity has come to the natural end of its life, or funding has been cut, but there aren't really any liabilities of the company, and it's just needing an orderly formal wind down. And what would happen in this case is the trustees would place the charity into a members' voluntary liquidation, and then the proceeds would be distributed depending on the articles. It's normally, you know, when we've seen it in the past, it's been to a charity which provides a similar service or something like that.
It can be a good way with the solvent liquidation for people involved in a charity. We dealt with a charity that had got, you know, significant amount of money in the bank, but they knew they were no longer going to be able to trade because the funding had stopped. And they didn't want to just carry on trading whilst ever the money was there until it ran out and just close. They wanted to see the good work continue in that particular field in which they were helping people. So they carried out the solvent liquidation, and it was hundreds of thousands of pounds, was then paid out, according to the articles, to, as Danielle said, a charity with similar objectives. And that really rested well with the, you know, with the trustees and anybody else involved with that particular charity, because they saw that as a legacy, and all the work that they'd done over the years was able to continue. We've also done solvent liquidations as parts of restructures of charities have merged into other charities. And if, you know, if that was something that anybody wanted further advice on, we could do that on a one-to-one basis.
And I think the main point from all of this to reiterate would be actually the duty of yourselves as trustees managing the charities, and also the overlap with them being a director if you are of the charity, and the obligations. And I think it is just continuously reviewing the position and forecasting into the future, not just looking at the current, because we are in uncertain times, things do go up and down. And I think then whatever decision you as trustees make for the charities is documented. And so if in the future, you know, it could be several years down the line, somebody would go, actually, why did you make this decision? You can actually go, look, we sat as a board, we discussed it, reviewed it, and we believed based on X, Y, Z that we were okay to continue trading. And I think all it really does is it protects you as trustees against any potential action should the charity become insolvent in the future.
One of the things that we've been asked to do by many boards, and we're more than happy to do so, is sometimes just to come and provide advice depending on the financial position, looking at the financial position that the company and charity finds itself in at that time, and then provide advice to the board. And it often provides reassurance to the board as to the actions they're taking, particularly in respect of continuing to trade. And that's something that if anybody listening wanted us to do, or even do, you know, come and speak to the board at a board meeting, just so that others are aware of their duties and responsibilities. Again, that's something we'd be more than happy to do and support you with. So our details are on the slides, which I believe are going to be shared. And I think we just wanted to see if we'll open it up to any questions if anybody has them. But if not, and you wanted to speak to us or email us separately afterwards, please do so.
Thank you ever so much. That's brilliant. As I say, there is the time now to ask any questions if you want to put any questions in the box for me, for Danielle, or for Deborah. Whilst you, some of you may be busy popping your questions in there. I just wanted to draw to your attention that we have got some more events coming up later on in the year, one next week actually, employment law updates. We've got sexual harassment training, which any of you have spoken to any of us recently, you will know there's going to be a change in the law in October in relation to sexual harassment, and therefore we're wanting everybody to be up to date and know what they need to do in that respect. So we've got a couple of those sessions lined up, and then we've also got a confirmed date now for our Bhayani Bollywood Ball. So that's celebrating our 10th anniversary in September. Deborah and Danielle, I'm sure you'll be there. I don't even have to ask if you're coming. I'm sure you'll be there. And so that's on the 21st of September. So do get in touch if you want tickets for that. I know there are a couple of more slides, but I'll just jump straight back to our questions. And if anybody does want a copy of all of the slides, you will, if you fill in the feedback forms, then one of my colleagues would be more than happy to send the slides to you. I think there's an option to tick a box and you can see the slides. They'll be sent back to you once you've completed that feedback form. So if I just stop right there, I'll be able to see if there's anything anybody has asked. I don't think there have been any questions, unless anybody else can see the questions.
We can't see any here on our side.
No, we must have explained things so well that nobody needs to ask a question. Perfect. Well, I think that's all from us then. So thank you everybody for joining us today. And if there are any questions, obviously, when you get a copy of the slides, both our contact details and Danielle and Deborah's contact details will be on there. So obviously you can just drop us an email or give us a call. And I'm sure we'll be more than happy to answer any questions that you've got. So thank you very much for joining us today, Deborah and Danielle. That was really, I found that very interesting. And I actually learned quite a bit, so thank you.
I think someone just said that. I saw a pop up on the screen as a message, but it was just somebody saying thank you.
Oh, fabulous. Lovely. Well, thank you very much for joining us.
No,
and we'll end it there, guys.
Thank you. Bye-bye.
Thank you. Bye-bye.